Good morning, Standard 10. Welcome back to the second module of the second chapter in civics, the Union Executive, the President and the Vice President. We have already covered the qualifications for election as President, his term of office, impeachment, vacancy, procedure for election, oath of office, executive and military powers in the last video. Now we proceed with the legislative powers of the President and the other powers as well. Legislative powers. The President has the power to summon and prorogue Parliament and dissolve the Lok Sabha. Summon means to call and prorogue means to discontinue a session without dissolving it. The President nominates 12 members to Rajya Sabha from people eminent in literature, science, art and social service fields. The President addresses and sends messages to both houses of parliament assembled together at the first session after each general election and at the commencement of the first session each year. So this is the time that he addresses a joint sitting of both the houses. The President has to give his or her assent for a bill to become a law. He can send the bill back for reconsideration if it is not a money bill. Money bills cannot be introduced except on the recommendation of the President. The President, on the advice of the Prime Minister, can issue an ordinance. Now, what is an ordinance? These are temporary laws which are promulgated by the President of India, which will have the same effect as an act of Parliament. They can only be issued when Parliament is not in session. They enable the Indian government to take immediate legislative action. Ordinance must be laid before both houses when they reassemble. If Parliament disapproves, the ordinance lapses. If it is not disapproved, it will automatically cease to operate at the expiration of the 6 weeks from the reassembly of Parliament. Next, we go on to financial powers. The President shall cause to be laid before both the houses the annual budget. He can ask for supplementary grants from contingency funds. A money bill cannot be introduced except on recommendation of President. He also appoints the Finance Commission after every 5 years, which makes amendments, enhancement, etc. Judicial powers. The President has enormous judicial power. He or she has the power to grant pardon or reduce the punishment that a person receives. The President is not answerable to any court for the exercise of the powers and duties of his office. No criminal proceedings shall be instituted. That means it can be started against the President in any court during the term of office. You can also see how he exercises the judicial powers, which are the different means. Next, we move on to emergency powers of the President. An emergency is a sudden or unforeseen situation demanding immediate action. The President is empowered to declare emergency in 3 cases. First, arising war or external and internal aggression. Second, breakdown of constitutional machinery. And third, financial emergency. Apart from these, the President also has certain discretionary powers which he can take his decision. He may withhold assent to a bill if it is not a money bill. There is no time limit within which the President is to declare his assent or refuse or return the bill. Then there are certain cases in which the President can take his decision. For example, if there is a situation when when no party or leader seems to enjoy majority, the President can have the freedom to decide who should be appointed as Prime Minister. These are the emergencies of 3 types: national emergency, state emergency and financial emergency. We shall study each type in detail. As I told you, emergency powers deals with unseen contingencies. Now, the first kind, emergency due to war. This is national emergency, which means it is proclaimed in the entire country when the President is satisfied that the security of India is threatened by war. Such a proclamation must be approved by both houses of parliament within 1 month. What are the effects of this emergency? So long as emergency lasts, the federal provisions of the Constitution to some extent remain suspended. Fundamental rights also remain suspended in this national emergency. You can see the slide. which lists down the various points of national emergency. Next, we have emergency due to failure of constitutional machinery. If the President, on receipt of a report from the Governor, is satisfied that the government of a state cannot be carried on in accordance with the provisions of the Constitution, he may declare an emergency in the state. This is also known as President's rule, as he assumes or any other functions of the government of the state. The duration of such a proclamation is of 2 months, but there are certain provisions when the President's rule can be extended. Now, what are the effects of state emergency? State legislative assembly may be dissolved or suspended. The annual budget of the state is passed by the parliament. Now, we move on to the third type of emergency, that is the financial emergency. This emergency arises when the financial stability or credit of India is threatened. Financial emergency should be approved by Parliament if it is to be continued beyond 2 months. The effects of financial emergency: the President can reduce salaries or allowances of persons employed by Union government. The Union government may ask the states to reduce salaries and allowances of those connected with state governments, and all money bills passed by state legislators may be reserved for consideration of the President. Next, we move on to the Vice President. At present, the Vice President of India is Venkaiah Naidu. The qualifications to contest for Vice Presidential polls are: he must be an Indian citizen, he should be at least 35 years of age, qualified to be elected to be a member of Rajya Sabha, and not hold any office of profit. Next, we move on to the term of office. The Vice President's term of office is for 5 years and he can be re-elected any number of times. However, the office may be terminated earlier by death, resignation or removal. Now, how is Vice President of India elected and how can he be removed from his office? May be removed by resolution of Rajya Sabha passed by majority of its members and agreed to by the Lok Sabha. There is no provision of impeachment for Vice President. How is he elected? He is elected by electoral college consisting of the members of both houses of parliament. The state assemblies do not have any role. He takes an oath by the President. Now, powers and functions of the Vice President: he is the ex officio chairman of Rajya Sabha, thereby he controls the meetings of the Rajya Sabha, and he is also the acting president during his absence. Supposing if the president is not there, then he acts as the president. So he discharges all the president's functions in his absence. So those were the powers of the vice president. You can see the dissimilarities between the president and the vice president when it comes to functions. President has executive power of the union vested in him, and Vice President does not have any special functions. That was all for the chapter, the second chapter, children. Do take care of yourself. I hope you have understood all the vital points in the chapter. Thank you and goodbye.